judge for the court for all and you go for God save the United States of America, to the state of Florida, in an honorable court. Please join me in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I thank you all. Good morning and welcome everyone. May be seated. Introductions. I'm Judge Jared Smith, and to my left we have Judge Rachel Kamutzis, and to my right Chief Judge Dan Traver. And if you're wondering why all these folks are in the room, that's partly my fault. I'm doing a homeschool mock trial here tomorrow, and I offered the courtroom for everyone to come and observe to see what this courtroom would look like. And I said they might get a chance to see some people argue some actual real cases, and I'm sure they will be impressed by counsel's presentations today. So with that said, we are here for our first case, which is David Olson, MD versus Christopher and Tammy Costello as personal representative of the estate of Ryan Costello, deceased in Infinite Health Collaborative, PA. Case number 250824. And counsel for the appellant, if you would want to come forward and then let us know how much time you would like to reserve for rebuttal.
And good morning, Nate. Please the court. Dinah Stein on behalf of Dr. Olson. Just for clarification, these were listed as two oral arguments, but it's the same counsel, same brief, so I presume it's the same oral argument. With that, I would ask for 5 minutes for rebuttal. Thank you.
Thank you, counsel. You may begin.
And we're here today, of course, on the question of whether a Minnesota doctor who comes to Florida in the course of his work and treats a professional baseball player on the same team that he works for is protected by Minnesota workers' compensation immunity or Florida law, no immunity under Florida law. But I'm going to start with the threshold issue, and that is, can we even be here talking to your honors today? Is there jurisdiction? And I take jurisdiction to be two-part. And one is, can we be here at all? Does this fall under Rule 9.130? And number two, assuming there is, can the court get to our second part question, which is, if Minnesota law applies, can this court determine whether or not the workers' compensation law applies?
I like how you frame that, but I just want to throw one wrinkle into it, which is that in your initial brief, you talked about this court having jurisdiction over a series of two orders. So I look at this as two separate cases with two separate orders, and that we would have to have jurisdiction to review each of those orders. And this isn't like a final appeal scenario where a final order then gives us the ability to look back at every interlocutory order beforehand. This is a situation where I think, and you can correct me if you think I'm wrong, where we would independently have to be able to exercise our power to review each of these two separate orders. And I'm struggling to see how we have jurisdiction over the first, just as a preview. And then secondly, I'm struggling to see how we have jurisdiction over the alternative finding in the second. And we did put you guys on notice as it relates to the OA about this triad of Supreme Court cases, Reeves, Culver, Hastings, that seem to discuss the idea that we would not have jurisdiction over that first order and then the backup order of the second. I'm willing to be talked out of it, but it's hard for us to overrule the Florida Supreme Court.
No, and thank you, Your Honor. And I understand, because originally the court denied summary judgment. And the way I see this, and of course, if you're an appellate lawyer with an order like that, you appeal. And then because we knew there was another one coming. And the way I read the court's three orders, because she issues the first of denial, then sua sponte the same day says, but I'm determining this as a matter of law, and I'll see you again after more briefing. And so the second order adopts the findings from the first and says, this is where we stopped and let off, and this is where we end up. And so I think at the very least, I see them as a combination of orders that can coalesce, if you will, into the May 23rd order where she makes her final findings. But Judge Traver, I'd agree with you that if it was just that order and nothing more, it could be more problematic under the Hastings.
What if you had a situation where it was done via cross motion for summary judgment? I mean, the distinction that you're trying to make, which is this was all one seamless thing that ended with this order, I appreciate. But would your thought on that be completely the same if it was a cross motion for summary judgment where your client's was denied and your colleagues was granted?
I think we'd have a different order, and so we could be talking about that because the
What if
judge,
they did it via two different orders though? Like, and I recognize that that's not usually the way that trial judges do these sorts of things, but what if they did it in two different orders? How could we have jurisdiction over the denial?
right, understood, and maybe I could make this easy. I'm not sure the court has to review that order,
The first one.
the first order.
I think from a substantive perspective, you're probably right, except I think you're going to run potentially into the same problem if you start talking about the alternative findings on the second order. So the second one says, hey, if I'm wrong,
Mhm.
as a trial court judge, then I think that there's genuine issues of material fact here that relate to the application of Minnesota law. So if you and I can't speak for my colleagues up on the bench here, if you and I are on the same page that we don't have jurisdiction to review that first order, then what say you to the alternative findings in the second?
So, and yes, so, and I think we could draw a line, and I believe it's page 6 of the order where the court makes her legal finding and says, this is it, it's Florida law, and then says in the alternative, and judges are allowed to rule in the alternative. It's, helpful to everyone just to know, but it does not change the impact of the order at all. It's not, I mean, I wouldn't call it dicta, but it's essentially what
It's an alternative finding, but I think the
Right.
rubber hits the road if we agree with you on before page 6. Let's say, for the sake of my question, that I agree with you that before page 6 that the trial court erred. As it relates to that alternative finding, can I even listen to you this morning? Do I even have the power to listen to you this morning as it relates to that alternative finding? Could we possibly take power over this particular case and reverse for entry of summary judgment on your client's behalf? And if so, yeah, how does that
Yeah.
line of case law allow us to do that?
So the first part of that is I absolutely believe, and I believe Reeves supports your reversal on just the finding that Florida law applies. In other words, this court has jurisdiction to hold that this was a mistake under the choice of law. It was a wrong analysis under choice of law. It's Minnesota, and stop there. I mean, let's just say that for, without getting into the rest of it, I believe under that, absolutely, because Reeves says you look at what the order does. In Reeves, it even though it didn't say it, it said it's clear that this is going to a jury for facts, and ergo, there's no jurisdiction. And here it's clear this isn't going to a jury. We're done. I mean, there's nothing more for it to be done on workers' compensation. It's over. And if I went back to the trial court and said, yes, but your alternative finding, she'd say, so what? That's an alternative finding. Your Honor's next question is, do you have jurisdiction to get past the top of page 6 and rule on the rest? And I will, this is our argument because I've looked into this and I don't know that the cases directly address it, although I did see one, which I'll tell the court about. Once we're in the door, I'd submit the court has jurisdiction and more discretion to be talking about things. I know that the Supreme Court does it. This is not the Supreme Court. It's a different jurisdictional analysis, but they traditionally will review non-conflict type issues. And I'm not sure what the constitutional authority is there other than you've gotten into the Supreme Court and they have jurisdiction. And now there's a discretionary element to that. I will point out to the court, we cited to a case called Wield Industries. It's from the 5th District, where it was similar to this. There was a finding as a matter of law and then a intentional tort type, it's going to the jury finding. And the court reviewed the matter of law one and then said, we don't have jurisdiction to review the finding of fact. But there was no analysis. And of course, as we know, this court doesn't necessarily always follow the 5th District. So I would say without any analysis, it's not binding. And I haven't found any court really addressing that.
Yeah, it's a weird, I haven't either. It's a weird sort of like procedural posture. And I swear I'm going to let you get to the substance of your case in a second. And I appreciate you indulging the jurisdictional request, but it's important. It's this idea that's in Reeves, and in Hastings that says, hey, the jury could bail you out. You know, in other words, if you're not successful, if we don't have the power to give you what you want at the end of your initial brief, you could still moot that issue by prevailing on it in front of a jury that decided that Minnesota law did apply. So that's just my personal struggle, and I will stop hogging the bench.
No, and I think jurisdiction is extremely important and, you know, something, and I will point out, and it's not that this is meant as a compliment to my opposing counsel, who's excellent. I mean, we had cases against each other and they didn't challenge jurisdiction. And that is, you know, we have an order that does what Reeves and Hastings say you need to do to get into this court.
I'm
And
gonna
then-
ask them about before page 6, because if that Reeves case law applies as it relates to the order granting summary judgment, I don't know that it does, but then we don't have any power to get to the substance of this case at all.
And I will just push back and say your honors do, because it's exactly what your honor just said, is that when this is not a situation where this is going to go back to a jury and maybe it'll correct itself. The jury will find there's workers' compensation immunity, and then we could come back here and, you know, talk about findings by the jury. We're done after page 6. And like I said before, if I went back to the court and said, what about after page 6? It would be a so what? That I already said Florida law applies. I said Florida law doesn't allow workers' compensation immunity. And so we're done with workers. So it is a question as a matter of law that we don't have workers' compensation immunity, and it falls right under the rule. The rest of it, it's a bigger ask. We believe your honors do have jurisdiction, and I've told your honors about the case that says you don't, but again, I don't think you need to follow it because there's absolutely no analysis. It just cites to Hastings, and then, you know, goes on. So we would ask, at the very least, that the court, I'm going to talk about the merits now, rule on the merits of the finding, and I'm going to get into that. So for the more fun part, choice of law. You know, we've made our arguments, and I think the key thing we're coming here, you know, want to just make clear is that this is not a medical malpractice necessarily analysis or a tort analysis under choice of law principles and the significant relationship test or relations test. We're talking about significant relations under workers' comp immunity, and that's the focus of this. And so when we look at the 4 factors, and then we consider the section 6 considerations, it's under the lens of workers' compensation immunity. And so that's where the analysis has to be. And, you know, this is either, as we've said, it's either a false conflict in the sense that Florida law doesn't even get in the business of professional athletes and workers' compensation immunity. They just stay out of it.
Isn't that a policy choice, though?
Absolutely. Absolutely.
And doesn't that, if I understand your argument correctly, doesn't it always become a self-fulfilling prophecy, though, as to favor the state that has the more developed workers' comp coverage?
Not necessarily. So let's say Florida law did have workers' comp immunity here, but it was a little different than Minnesota law. Your honor's point, I think, is it's well taken, because now we're just, you know, comparing. And my point is that when we're talking policy, and your honor said we're policy, it's a legislature's policy. The legislature said we're not in the business of workers' compensation with professional athletes.
But I guess my point is that's in and of itself is a policy choice.
Correct.
I mean, you've got different legislatures that are accountable to different citizenries in very different areas of this country, and they've made 2 diametrically opposed choices. It's very hard. And I guess this is a larger section 6 issue, because the way that you've looked at section 6, 2-part question. Number one, I'm not sure I understand the argument that the trial court didn't consider it when it says in the order that I considered it. And then separately, this categorical breakdown of section 6 does not seem to be the way that restatement section 125 is written. It seems to say that we're going to look at these 4 categories. And in looking at these 4 categories, we've got this holistic umbrella, you know, as it relates to section 6. If I've got either of those things wrong, please dispel me of that notion.
I agree with your honor, and I think that was what opposing counsel said. And I think it's just easier to it was easier to brief by just putting all the 6 together. But I don't disagree with that at all. I believe that is how the cases determine it. I'll just start going through the 4 factors and we could talk
That's
about
great,
those.
yeah. Yeah.
And maybe that'll give it context. And you know, the where the injury occurred, I will say this because plaintiff is saying the injury occurred as soon as the alleged negligent, I guess, treatment took place. Had Mr. Costello received treatment for his the syndrome, the WW syndrome, the next day and he was fine, there'd be no cause of action. This didn't become a cause of action until unfortunately he passed away, and that was in New Zealand. And as the court said, you know, New Zealand obviously has little interest in this and no one's asking for New Zealand law to apply, but that's where the injury occurred. So when we talk about injury, it's not this, and there's 2 factors in this test where the negligence took place, which is Florida, and where the injury occurred. So, you know, I know plaintiff wants to merge it all together in one, but this is a wrongful death case and the injury is obviously the death, and the death did not occur in Florida. And by that time, Mr. Costello was no longer residing in Florida.
Counsel, can you just go into that a little bit more in terms of assessing injury and the confidence that it happened by way of the death? You know, when I was first looking at this case, it struck me as the doctor failed to flag and diagnose the decedent appropriately, triggering the injury, you know, the events leading up to the death. So I don't know if it's semantics, but I am struggling with fully seeing the injury only happening in New Zealand. Can you kind of elaborate on how you're landing there?
Yes, Your Honor. And I think I don't disagree with how Your Honor's framing this. I mean, that's what, you know, the original act happened there. And what plaintiff is saying is that every day after that, the plaintiff had an injury, but there's no injury until the syndrome manifests itself. And so my point being, had it been treated, in other words, had he actually injured Mr. Costello in Florida, when he treated him that day, there'd be a tort that day and he'd have a cause of action that day. That didn't happen. He could have sought treatment after that, but and had it fixed. The entire cause of action didn't arise until the syndrome that wasn't diagnosed or had told about manifested itself. And you know, there's a reason this test, the 4-part test, separates the 2. One is to look at the cause of action, where it occurred, Florida. The other is, where did it manifest itself? It's like, you know, the smoking injury case we pointed out, where the gentleman smoked for many years, but died or was diagnosed with cancer in Florida. There has to be a place where the negligence manifests itself, and that was in New Zealand. And
counsel, you are into your rebuttal. I don't know if you want to stop and save the rest of your time.
Unless Your Honors have a specific, you know, question regarding what we've argued, I think we've made our legal analysis pretty clear in the brief. So I'll save the rest of my time for rebuttal. Thank you.
Counsel, I'm going to stop you there. And this is what I should have done when I started because of all of our visitors. I'm off the clock. I'm going to give you 60 to 90 seconds to tell our folks here, what is this case about? And Mr. Elliott or whoever's speaking on your behalf, I'll give you all the same opportunity off the clock as well. So if you want to address the audience, just let them know, because my apologies, this is an appellate argument. This is not a trial, you know, like you see on TV. So.
The introduction, so you wouldn't be completely bored or confused, but I apologize for that. My client is a doctor who works for the Minnesota Twins, the baseball team in Minnesota. He came to Florida, to Lee County, to clear players with spring training, and one of the players was Brian Costello, who had a heart condition. And the allegations against my doctor is that he was able to see this heart condition on a patient and cleared him for spring training. And unfortunately, very tragically, this man died down the road in New Zealand of this condition. So we are saying that since this was all involving work, and I'm not going to get into the marriage or argument, you know,
This is involving work that our doctor gets workers' compensation immunity, because you can't be sued, and the plaintiffs are saying, you don't get workers' compensation immunity, under these facts in Florida, and this is a Florida case, so when we're arguing about Florida versus Minnesota, that's kind of what we're trying to get here, is we kind of want Minnesota law to apply, and Florida law to apply. And that's, I guess, maybe an overview of what this
Thank
case
you.
is about.
That was very nice. Thank you, counsel.
Good morning. May it please the court, Michael Levine for Tammy and Chris Costello, personal representatives of the estate of their son, Ryan Costello.
And Mr. Levine, I'll give you the same opportunity if you would
Sure.
like to talk to the audience before I start your time.
Good morning, everyone. First, I think this is an amazing opportunity. I wish I had something like this when I was curious. But I agree largely with what you heard from this time. My clients are the parents of the young man, Ryan Costello. Ryan was chasing dreams, playing minor league baseball for the Fort Myers Miracle, which is part of the Minnesota school system. And ultimately, prior to spring training back in 2019, he underwent a medical examination. That included a new ECG at the heart test, and there's no dispute at all that the heart test showed he had what's called Wolff-Parkinson-White, WPW. And WPW is treatable, but it's life-threatening and it's not. And there's also no dispute that it required additional workup to be treated, but unfortunately that never happened. And the exam was marked normal, it was marked no further action necessary, and Ryan never knew, no one told him. So he went about his life. 8 months later, playing baseball in New Zealand, doesn't make it down to the team bus, and he was diving to sleep in the sleep element. And so that's what this case is about, this action that occurred here in Florida, and we don't have an immunity for this, Minnesota does. So Dr. Olson is trying to take that Minnesota law, throw it into the Florida court system here, and we do know that's what this case is about.
Thank you, counsel. Thank you both. All right, counsel, you may proceed.
Thank you, Your Honor. So the trial court correctly concluded that Florida law applies because Florida bears the most significant relationship to this case and the issue of workers' comp immunity. And that is abundantly clear when you look at all of the factors, whether we're
Definitely going to ask you about jurisdiction.
Sure. And I'll jump right to it then. So with respect to jurisdiction, I think Your Honor hit the nail on the head. When you have that alternative finding under Minnesota law, there's issues of fact, then under 9.130, Dr. Olson would not be deprived of that defense if this court says Minnesota law applies. So if this court were to disagree, say no, Minnesota law
I'm going to
applies.
ask about, because I really did appreciate your colleague's candor on that. It's not something, it's the mark of good advocacy as opposed to bad advocacy. I'm going to ask though about what you're asking us to affirm, you know, whether we have the power to get to that. You know, we've got these Florida Supreme Court cases that talk about the need for specific words to be in an order. I think you'd have to concede that those words are not in this order, the second order on appeal. Do we still have the jurisdiction to review it though?
Sure. So this is a strange procedural posture because Your Honor's correct. Those magic words, so to speak, do not appear in the court's order. So the first part, the first 5 or so pages of the order is a choice of law decision. And so the effect of that choice of law decision is to deprive Dr. Olson of the immunity defense. I don't disagree with that at all. That's true. But if the court is saying Florida law applies, then there is no comp immunity defense. It doesn't exist. And what Olson has alleged in his answer and affirmative defenses is I get comp immunity under Minnesota law. And so those magic words don't appear. And so I think what Your Honor is suggesting is there wouldn't be jurisdiction to immediately look at a choice of law determination. I will agree, though, with what Ms. Stein said, which is the effect of the order is to deprive Olson of that comp immunity defense.
So you got to find a way then to distinguish that group of Florida Supreme Court cases from the situation that you have at hand. What's that distinction?
The distinction is really that the order deprives him of the defense entirely. And so he's going to go through the trial without that defense. And we think
is the distinction as easy as this, as those group of cases all talk about the denial of summary judgment? In this particular situation, you have summary judgment being granted.
I don't think that's the distinction here. I think the issue is the availability of the defense. the defense is available to him if this court decides Minnesota law applies, and that would be the end of the inquiry because there's fact issues there. If the court affirms on Florida law, there is no immunity defense, and that's what we believe this court should do.
Do you not think that that's a meaningful distinction, denial versus grant of a summary judgment?
I think in this context, the meaningful distinction has to do with whether or not Olson's going to have the defense available to him, and he's not going to. And so under those principles, we look and see, is Florida the correct law? And it is.
I see what you're saying, but like from a procedural standpoint, I'm struggling to think how you could grant somebody's motion for summary judgment on an issue. And is there a situation where that issue could ever still be at play at trial? Like, isn't it baked into the definition of summary judgment?
Just to make sure I'm clear, what your honor is asking is if there's a grant of summary judgment.
It
how-
resolves the issue legally, correct? Because if there's a factual issue, then summary judgment wouldn't be appropriate. So I think about the procedural distinction being that if there's a denial, there could be, I struggled with, I'll confess to struggling a little bit with the way that those Supreme Court decisions are worded, because I struggle to think of a situation in which summary judgment on one hand could be denied, meaning that there's genuine issues of material fact, and yet somehow there could be a situation where workers' comp immunity is resolved. Like I could not think of that situation, but it may be, I may be limited by my intelligence. In that other context where you've got summary judgment being granted, it seems like being baked into the definition of summary judgment is that this can be done as a matter of law. There are no issues of fact. So the jury has no role as a finder of fact. So we might be saying the same thing. I think you're talking about the effect though, and I might be asking you about the mechanism that gives rise to that effect.
Sure. And I think that's because of the interplay between the choice of law analysis with the comp immunity. So if the court's granting summary judgment to say Florida law applies, now we've removed comp immunity from the discussion at all. That's the strange posture that this issue comes before the court.
Right. The way that I've been talking to my law clerk about it is that if any lawyer tried to raise in the wake of this order, say it was affirmed, if any lawyers tries to start talking about work comp immunity at a trial, they're going to get yelled at. Like it's a closed issue, correct?
It's no longer in the case.
Yeah.
Because the way in which it was alleged was only under Minnesota law. The trial court's order is saying Minnesota law is not here, it doesn't apply. But when we look at why the trial court reached that decision and why it's correct, it's because whether we look at the 4 factors or the 7 of the Section 6 factors, they all show that Florida law has the overwhelming strong relationship with what happened here.
Could you address Judge Kamoutsas' question? You know, when I look at the way in the first 2 factors that injury is described, there's 2 different ways in which injury is discussed. Where it occurred and where the conduct causing the injury occurred. Do we read the word injury as synonymous with cause of action or defense? Or do we read injury as being something else?
I think it's something else. And I think that the distinction matters in certain cases more so than others. For example, a products liability case, the conduct may have occurred in some faraway place where a product was designed, manufactured, etc., but the injury may not have manifested itself until someone was using that product elsewhere. But I think if we focus on this case, the injury happened in Florida because exactly this distinction that Judge Kamoutsas was making, when Ryan was misdiagnosed, when the correct diagnosis was concealed from him, every day that went on, he suffered from WPW that he needed to be treated, but he wasn't. And so that's Florida. And the cases that we cite, the Fanning case, the Garcia case, they articulate this point quite well. You know, in Fanning, you had the prostatectomy that should have never happened. A gentleman in Colorado has a biopsy. The specimen goes off to a lab in Connecticut. They mishandle the specimen, mix it up with another patient. This gentleman ends up undergoing a prostatectomy in Colorado. Now, Olson would argue that's the injury. He had this unneeded surgery in Colorado. But the court there said, no, the injury was mishandling the specimen. The unneeded surgery was the manifestation of that. Same thing in Garcia. In Garcia, you had the flight attendant who was mugged in Florida, had a doctor-patient relationship in Florida, just like here. The malpractice occurred here. Then Garcia goes back to Spain and realizes there, hey, the doctor committed malpractice on you. The injury didn't occur in Spain when that manifested itself. It occurred in Florida when the malpractice occurred. And when we look at those two factors, with respect to place of injury, no one's saying that it happened in Minnesota. Olson just argues it happened in New Zealand. So that factor doesn't weigh in favor of applying Minnesota law. Then you look at the conduct causing the injury. Olson agrees, that's Florida. Of course it's Florida. That's where the exam took place. That's where they were. You look at the third and fourth factors. The third factor, domicile, residence, place of business of the parties. Olson is focusing on the headquarters of a non-party. What Olson is doing is trying to collapse the multi-factor significant relationship test into a new one-factor test. Where is the employer headquartered? That's not the test. That's not how any court that's applied this test in the work comp setting has ever gone about it. In Garcia, if they had used the Olson test, they would have said, well, it's Spanish law because they work for Iberian Airlines. And in Marion Power, they would have said, well, it could be Illinois or it could be Delaware because that's where those companies are. That's not the test. That's why there are these multi-factors. And so if we look at the residency, for example, Olson concedes Ryan was a resident of Florida at the time that this happened. He was playing for the Fort Myers Miracle, living in Fort Myers. Now, Olson's residence, obviously Minnesota. Then we look to the next factor, the place where the relationship is centered. Once again, Olson collapses this into the headquarters of a non-party, the Minnesota Twins. The relationship between the parties, there are two parties, Olson, Costello. Their relationship only existed here in Florida. And page 431 of the record, Dr. Olson says, Ryan was my patient. So what is the key relationship in this case? The doctor-patient relationship. Where did that exist? Only in Florida. So looking at those significant relationship factors, none of them weigh in favor of Minnesota. They weigh in favor of applying Florida law because Dr. Olson flew down to Florida. He performed a medical evaluation in Florida on Ryan Costello, who was a resident of Florida. That's where everything happened. A lot of the cases that Olson relies upon talk about the mere fortuity of a particular forum. And Olson tries to say that, you know, where he's at here is a bit of a fortuity. That's not so. Olson had been coming to spring training for years. Not only that, Ryan's not the only person that he treated that day. He testified that he did 40 clearance evaluations. So to suggest that this is akin to a road trip from Florida to North Carolina where an accident happens in South Carolina, that's not this case. This is a doctor who came down here as part of his work, performed 40 pre-clearance evaluations, one of which was on Ryan Costello, committed malpractice here in Florida, the only place their relationship existed, and now he's trying to escape liability by imposing another state statute. And so when then you look to the other factors from Section 6, and I think Judge Traver, you pointed this out with the Olson brief treats Florida, quote, as a hands-off approach. Not so. Florida, this is not an issue that Florida hasn't thought about, hasn't legislated, far from it. Florida did legislate this, just in a way that doesn't help Olson. Florida specifically carved out professional athletes from Section 440, the workers' comp statute. And so this is not an area where, well, Florida hasn't said anything, so let's look to another forum. Florida spoke. They said there's no comp immunity. And then if you look at the Rudolph versus Miami Dolphins case, the first DCA specifically noted that there's reasons behind that decision. And number two, the athletes have the civil court system available to them, which is exactly why we're here. So there's no policy consideration that would say Florida should bend to the will of Minnesota just because they've decided to enact immunity in this circumstance. Perhaps it very well doesn't apply, but that's something that the trial court said there was a factual issue on. So Florida has spoken. There is a strong policy interest in making sure that our courts are open for redress of torts, and that's what this case is. And when you look at, I guess, sort of an underlying theme of Olson's argument to collapse this test into one, where are the Twins headquartered? Olson treats that as being the most important because, well, that's where they worked, and this is a work comp immunity. But work comp immunity is immunizing a co-employee from a tort. The tort is intertwined in the defense, and therefore we have to look at the tort. Where did the tort occur? It occurred here. Where was Olson working at the time that he committed malpractice? Here.
That's not what subsection 1 says. It says with respect to an issue in tort.
Sure.
So it seems like that, and I understand why you would take this tack from an advocacy perspective, because if we're just looking at where the tort occurred, we're probably not here today. It's an easy call. If we're looking at where the issue in tort arose, aren't we looking at the way that section 145 of the restatement reads, with perhaps some of the later sections in the restatement which relates to defenses?
Sure.
Because you could have a situation, right, where a jury was instructed, I'm instructing you on the negligence law and the medical malpractice law of Florida, but I'm also instructing you to apply this Minnesota law for this defense. I mean, that's not, it's atypical, but it's not odd.
It's not impossible.
Yeah.
The courts recognize that there may be circumstances where two different laws are applied to two different issues in the case. But the tort is intertwined with this defense because the comp immunity defense is one that's tied to the tort itself. But either way, you still end up in the same place, which is that Florida law applies. Why is that? Because where was Dr. Olson working? Here. Where was Ryan Costello working? Here. They were performing their work in Florida. For Dr. Olson, his work was to come down to spring training, spend time with the Fort Myers Miracle, be available to those players, perform the clearance examination on those players. That's where he was working. And for Ryan Costello, where was he working? Here. He never stepped foot in Minnesota. He was working for the Fort Myers Miracle. So whether you even view it in such isolation to say, I'm only looking at this employment relationship, but the employment was taking place here. And that's why in the Garcia case, the 11th Circuit specifically said, this is not a contract case. This is a tort case. And so they were not moving towards, well, because you have this relationship with Iberia Airlines in Spain, we're going to apply Spanish law. No, they focused on where they were. And I think this case even furthers that point that it's not that they were here by some happenstance. This is where they were working. Ryan was assigned to the Fort Myers Miracle. Dr. Olson was directed to come do the examinations of the Fort Myers Miracle here in Fort Myers. So that's why the Florida law applies. Happy to answer any other questions about the factors, but I've gone through much of them and I don't see any that bend towards Minnesota. And I think the overwhelming issue here is when a doctor comes to this state, commits malpractice in this state on a Florida resident, Florida law applies. We don't take the Minnesota statute, particularly where Florida has already legislated this very issue.
Thank you, counsel.
Thank you.
Just some quick points on jurisdiction, and when there's no case and Reeves and Hastings don't preclude jurisdiction, the courts is just inquiry, whether how far we interpret them. But when there is no case on point, you can revert to the rule, and the rule talks about orders that determine as a matter of law there's no workers' compensation immunity. So that just under the plain language of the rule, that a party is not entitled to workers' compensation immunity. It's a pretty simple analysis because that's exactly what this order does. And as counsel concedes, we get back to the trial court level, there's no issue of workers' compensation anymore based on that order.
Can you address the fourth factor? Because I thought your colleague makes an interesting point, both in his briefing and here today. It doesn't talk about the relationship between the parties as it relates to the defense. If that phrasing was in there either in section 145 or in section 161, which generally just points us back to 145, maybe there might be more of a hook on that. But the way that I just plainly read that is the place where the relationship between Dr. Olson and Mr. Costello took place. First off, do you read that differently? And secondly, how could we have any other interpretation that the place where their relationship is centered is the only place where they ever actually met each other?
Oh, sure. I'll start by, and I was going to point out that Dr. Olson, as to that, could not have treated Mr. Costello in Florida, but for his employment. That he's not licensed in Florida, and there's a federal statute that allows team physicians to come to other states and treat players. So, but for his employment, he couldn't have ever, the tort couldn't have taken place. So can we say that this is just, it's not like the twins sent him to a local doctor's office in Florida, and that's the Garcia case where he's treated. They sent their doctor to Florida under this federal statute to clear Mr. Costello.
I don't necessarily know what bearing, I mean, I get that the twins kind of permeate and umbrella this entire case because that's the mechanism that brought these parties together. But if I look at the language of the factor, where the relationship between the parties is centered, the parties are these two parties. It's not the twins.
And I'd submit that's where the Section 6 factors come to play, because now we're talking about the continuity, the policies. I mean, this, as we know, Mr. Costello was injured in Mississippi and got workers' compensation immunity. And now we come to Florida under the same, different situation. Now we have this statute that allows the team physician to come there, and there's no workers' compensation immunity. That's why I don't think you can just untether this from the twins.
Does that reading always make the parties' shared employer kind of like a Section 6 super factor, though, as it relates to workers' comp immunity? Wouldn't that, under that interpretation of this, wouldn't that always be dispositive for workers' comp immunity? Who's your employer? I mean, and I would think, there are a couple in the restatement, the section on defenses, there are a couple of immunity restatement things, but workers' comp immunity isn't one of them. And for example, if you're talking about like family immunity, it talks about the place where the family is domiciled kind of being the super factor, but there's no super factor that I'm reading. And please correct me if I'm wrong, but there's no super factor as it relates to where the parties are both employed.
And we haven't advocated this as a super factor. I'm not sure that it necessarily is, because there could be other factors involved. I mean, every case is determined on its facts. Here, perhaps we are elevating it higher than we would in another case.
I think you'd have to because
yes.
of the nature of the defense. I think where I'm having some trouble with it is I don't see anything in Bishop which adopts the restatement to be able to say that that's so. Because it's 4 factors,
Right.
whether it's a defense or whether it's, and we talk about one maybe being more important given the particular context of a defense or a case. And I think I understand your argument to be because we're advancing a workers' comp defense, that all of a sudden elevates. Yeah.
That's exactly where I was about to go, is that,
Yeah.
and that's what Bishop says, and the other Stallings, the other cases we cite to, is that every case, that's your first step in this entire analysis, is what are we even talking about legally? And if you're talking about an auto accident and let's say vicarious liability or dangerous instrumentality, that's your lens, your focus, where the factors are going to look, more towards. And here it happens to be workers' compensation immunity. I'm not sure you can just untether the employer and say, well, Dr. Olson happened to be in Florida when he couldn't have been here treating Mr. Costello, absent that relationship where they both worked for. So perhaps it is a bit of a super factor, but we're not asking the court to disregard the other factors, which certainly don't weigh against us. I mean, Mr. Costello wasn't even living here when the unfortunate event happened. So, I mean, this has a lot of factors that don't weigh in favor of Florida.
Counsel, I know we're past time, but any
I'm
other
sorry.
any other follow-ups? It's hard for me to yell at the chief judge.
Appreciate the indulgence. We would ask the court to reverse this order. Thank you.
Okay, thank you, counsel. All right, and we will be in recess, and thank you both for explaining your cases to our audience here. We'll be in recess for a few minutes.
Thankfully that you can do it over. When you're not done. As a pocket. Are we good? Yeah. Don't stand for it. Just. Yeah. Well, my phone has been lucky. Oh, the other one, I have the 11/98. Oh, this wasn't now.
Came up and. Yeah, I know. Fine. Yeah, I